Slide with me while I review a sexual harassment lawsuit. I'll explain to you the logic and the law behind my review. Okay, so a lawyer has provided the following information of a potential new client just got fired because she did not complete her training program. Her supervisor, her boss, sexually harassed her. Number one, he asked her if she spit or swallows. Two, if he can swab the back of her throat with his number, and asked her to send pictures and sending her sexually provocative memes and cartoons. And all of these were screenshotted by the lady that was fired. Okay, so the company's a multi-million-dollar company with $6 billion in revenue. So sounds like a solvent employer and sounds like a horrendous sexual harassment situation. But let's take a look at whether or not this is a good lawsuit or not. So the first question I had is, did she complain prior to being fired? And so I think that it is important to do that because it's one of those checklist items. And I'll explain to you why. Normally, someone listening to this egregious situation would say it's a bad situation for the employer, good lawsuit for the employee or the ex-employee. But you're going to face a couple of problems in Texas if you file this lawsuit. Number one is that you have to prove that the young lady or the lady is in a protected group. The answer is yes, she's female. Number two is she was subject to a unwelcome harassment. Number three, the unwelcome harassment was based on her sex. Now, the additional item, which is all bet, is that number four is that the harassment resulted in a termination. It's called affecting the terms and condition of employment. And so being fired is a term of condition. So all four elements were met, but there's a fifth element, and that is she has to prove that the employer knew or should have known of the harassment and failed to take prompt and remedial measure. Now, I don't make up the rules. This is the law in the Fifth Circuit. And so the fifth element is key here. How do you prove that the employer knew or should have known about the sexual harassment? If she did not complain, then they could argue they have deniability. They'll just say, oh, we didn't know. We fired her because she didn't meet all of the training criteria. It's a non-sexual harassment. It's not retaliation. It's not sexually motivated, not sex motivated at all. So that's deniability. And so in this situation, you want to complain about the sexual harassment, and the higher you go up or the louder you complain, the better. So if you complain to, say, a coworker, there's still deniability. The employer may say, well, we actually had a sexual harassment complaint process in place. Unfortunately, this person didn't go through that process, so deniability, we didn't know. And so it's going to be a factual issue in the lawsuit. The threshold item is, can we prove that the employer was on notice? Now, as a plaintiff's lawyer, I can tell you this trick. I can say it's a trick, but it's permissible. It's when you file this lawsuit, you don't have the internal communication. And so it's easy for the employer to hire a defense lawyer to file a motion to dismiss saying, you're missing the fifth element. You didn't prove that we knew. So unfortunately, your lawsuit must be dismissed on its face unless you can come up with some facts. And so it's really difficult to do that. But I have some ideas on how to overcome it. Okay, back to work.